So Mark is a wealth of technical expertise there and information on this. I'm going to give you the kind of the legal picture, and I'm afraid some of it is, it's pretty drab in a way, but we'll go through it because it's fundamental and people need to be aware of really how, I suppose, the regime that sets all this up allows it to happen, and at the moment, in terms of our view, coming from a perspective of what is a kind of best practice legal regime and regulatory regime and compliance regime for this kind of industry. And you've compared it here to, what we've seen with coal mining. And I mean, anyone who lives in the Hunter Valley can tell you that, we probably could have, ought to have, and still can do things a little bit differently in terms of legality and the way communities are dealt with and the types of rights that communities have. Basically, the very, very basic premise and the particular legislation that kind of administers and regulates and sets forward the scheme for companies to come along and engage in something like coal seam gas exploration and extraction is our petroleum legislation. And it functions on the very, very basic premise that all petroleum below the surface of the land belong to the Crown. So, automatically there, it's that idea, when you buy your own land and you look at your property title, that, the minerals below the surface are reserved and they are owned by the Crown. So then, of course, on top of that, anyone that owns something generally has a right to go and retrieve it one way or another. So the legislation is a 1991 piece of legislation. It hasn't been amended very, very much, unlike our environmental planning and assessment legislation that's been amended more than any other piece of legislation in the world. This legislation's pretty much stayed as it is. And then since 1991, it replaced legislation that was fairly similar. And it is based on, the whole premise is based on this notion that the Crown owns the petroleum or the hydrocarbons, and the legislation gives the kind of yellow brick road on how to get it out of the ground. So what we know now, though, is that when we find out that there is a worthy resource under there for a company to go and extract for production, well, then there may be other approvals required. So under our Environmental Planning and Assessment Act, a company, once it moves from an exploration phase, is then required to go and get what we call development consent or development approval. There are also other layers of law in terms of the approval process that might be engaged in the process. So at the moment, what we've just seen out in the Pilliga this week was that because the kind of gas project out in the Pilliga is such a massive one in terms of the geographic area it's going to take up, and also the sensitivity of the landscape out there in terms of some of the state conservation areas. This week it was declared that gas project out there, including a number of pipelines that will transport the gas from that area, that's going to also require Commonwealth Government approval. So you can see there's going to be, in a project that size, there's a few layers of development consent required. So there will be an approval under our state government legislation that's required, and then there will also be approval from our Environment Minister, Commonwealth Environment Minister, that's going to be required as well for that particular project. And then along with that, there will be also a petroleum production licence that's required under this petroleum legislation. So I suppose that's kind of the sort of biggest example. So that's when a company goes into, we've done our exploration, we've got our plan for production, and we're going to use this particular resource outside of the area. So that's when we start looking at development applications that the public are made aware of, and the public can then have a say in those. So, for example, what happened with the Metgasco power plant, Metgasco put in a development application to the New South Wales Planning Minister and said, I'm seeking an approval under Part 3A. That legislation's now been abolished, so we're not sure what the next thing that will replace that for these kind of proposals. And of course, when I say these kind of proposals, I'm talking about proposals that are arguably state significant kind of development. So not necessarily the sort of development that your council is going to be consenting to. So at the moment, as I say, we've got a Part 3A approval for the Metgasco power plant. There was no Commonwealth approval involved in that, but that development, so that project, it went out on public exhibition, and there was an opportunity then for people to participate, look at what the proposal was for the power plant, look at the amount of wells proposed, where those wells were. There were a number of assessment documents that people could have looked at and said, how they think this project looks to them. There's normally a 30-day window for people to kind of lodge their submissions about these proposals and say what they, what they think about the project in terms of what the merits are for that project. So there's a few layers, but basically at the moment, other than that kind of Metgasco power plant, at the moment we're still in the exploration phases. So the other PELs that Mark identified on the maps, really they're still in exploration phase only. Now, the State Environmental Planning Policy for petroleum projects basically says there's no development consent or approval required for exploration activities. So all we get in terms of an exploration, and I'm talking about the law as it is, because we're told that there may be we're told that there will be some changes in the law, but as I say, we haven't seen those yet. The last government, the Labor government, had basically announced that it was introducing a kind of tough new regime, and that was going to be exploration licences. Applications for exploration licences were going to be exhibited to the public, and the public was going to have an opportunity to have a say in those, as well as all of the relevant government agencies such as the Department of Planning and the then Department of Environment, Climate Change and Water. They were all going to have a say in these exploration licences, but we haven't actually seen anything yet. And as Mark said, we even contacted one of the departments, the now Office of Environment and Heritage, to basically say, look, have you seen any of the new refs from the areas outside of this area? And basically the answer was no. So, there was this announcement by the last government, but there was clearly no necessary there was no legislative change. So of course this current government isn't necessarily bound to anything that the last government proposed. In terms of making the regulatory regime more involving of the public and kind of more rigorous in terms of looking up front at the potential environmental impacts. So so as Mark identified, there's this talk that we won't have the kind of royalties on exploration activities, and they won't be paid up front, which ultimately could make a quite a major difference in the long term. Because, the way the system works at the moment is, if you are a company, if you get an exploration licence and you find resource and then you get development consent, you're fairly much guaranteed you will get a production licence. In fact, the law basically says, as a company, you can expect that you will get a production licence. So it's not like there are many. Once you've got that development consent, fairly much you're on your way in terms of a company. So in terms of those kind of, the power, say, of veto or stopping a particular project for a particular environmental reason or because a community doesn't want it, those kind of legal measures really aren't built into this current legislative regime. It's very much, if you've done the right thing, if you're a company, you've done the right thing with your exploration licence, you get your development approval, it's off you go and it's business. So as I say, the types of titles, we call them petroleum titles. So there's exploration licences. Exploration licences, as we've identified, no development consent, you just apply for them. There's a few things as a company that you have to kind of show cause. You've basically got to show that you're a bona fide company, you've got kind of investors, you've got money and you're in the business. Once you've kind of shown that, you can get an exploration licence. These are valid for 6 years, but they can be renewed. There's a few conditions about, how you renew. Basically, you've got to do it within a time frame, but even that can be waived too if the minister wants to. up to 140 blocks in your area. There's under your exploration license. There's also some kind of technical requirements about having to relinquish certain areas at the end of renewals, etc. Because they're trying limiting. I suppose it's certainly not my area of expertise, but I suppose the intention behind it is to keep that competition healthy between companies in terms of working to extract these resources for the benefit and royalties that then go back to the Crown. Yes.
What is a block?
A block. I'll look at that. I'm not exactly sure. Is it a...
It's I don't know the dimensions, but it's based on a reticulation of the Earth's surface.
Yeah.
So they divide it up by latitude and longitude.
And it is actually that...
And there's a maximum number that you can apply for with any lease.
It talks about the meridian of Greenwich and meridians of longitude that are at a distance from the meridian of 5 minutes or a multiple of 5 minutes of longitude, and by the equator and by parallels of latitude that are at a distance from the equator of 5 minutes or multiples of 5 minutes of latitude, into graticular sections, each of which is bounded by portions of 2 of those meridians, and it kind of defines it in that kind of context in terms of what... You know that thing?
That's 100 square miles.
Gotcha. Cool, that's it. So so that's basically the blocks are kind of defined like that.
The further away you get from the equator.
Yeah, well, and here we are. That's right. So there are also assessment leases. These are only used where the licensee isn't kind of ready to produce it. So I think Mark indicated earlier they're these kind of holding zones. And then the ones that so really the focus for, I suppose, that where things happen legally is the exploration licence and then the production leases. And as I said, fairly much when you've had your exploration licence, you get your development consent, the law says you can expect to then be granted your production lease. Now, the production leases are up to 4 blocks, but they last for 21 years. So clearly you're looking at a more confined area for production, which would make sense in any scheme, in any scoping kind of activity. You're allowed a much broader area to look and see where your bets are, but then they're limited. The companies, in terms of what they're entitled to hold for production, are limited to a lesser area. And of course, the guarantee of making it an economically viable project, you get these production leases for 21 years. So one of the things I suppose that we as an organisation have been really critical of in terms of, the kind of robust nature of an environmental assessment process is that in terms of the exploration licence, really what we've seen is these, as Mark referred to them, these documents, review of environmental factors. Now, some of the refs I've looked at for exploration activities, I would say are really, really poor. And I won't name which ones or where in particular, but some of the ones I've seen have been and maintained this kind of tick box approach. And I suppose to some extent that's because there is some kind of, I suppose, there has been for such a long time this kind of laboured assumption that exploration activities are fairly benign, that they're they're literally just looking projects. Well, what I've very recently discovered in terms of an exploration licence, and this is out further in the northwest, is that an exploration licence can also give a company the right to do some pilot production activity. Whether that's legal, I don't know. I'm looking into that question. But, really, this sort of stuff is I suppose, it's developed through the practice that industry has told government, in terms of government being the approval authority, these things are necessary for us to understand whether we've got an economically viable kind of interest project here. So, so really what from a critical analysis of what's happening on the ground with some of this stuff, and in a way how slow the law is in being able to respond to this, is that we're getting certain activities happening in our environment and our local communities that in law require a much more vigorous environmental assessment process, one that you as members of the community have a right to participate in, but they're happening at an end under a licence that is being, that really nobody got a look in, nobody even knew it was going to be granted in the first instance, and the type of environmental assessment we've seen for it is what we call a review of environmental factors. And as I said, some of the ones I've seen are incredibly poor, and even the things that have been committed to in some of those haven't actually been carried out on the ground into practice. So, I mean, at this stage, in terms of looking at a kind of a legal system or a legal regime that purports to regulate a particular land-based activity, I would have to say that in my years of experience, this stuff is some of the most alarming I have seen. So really, I suppose the weight at the moment or the level of concern in the community, I would say, is really justified from my very narrow perspective, looking simply at the legal regime that regulates this particular activity. Clearly I'm not a scientist. I don't know the extent of the environmental impacts, and like any other individual, I can see that in front of me and say, gosh, that could be a problem. But in terms of just looking at a very, very strict critical analysis of the legal regime that is regulating this industry at the moment, or this activity, I would say it's way, way, way back there. I mean, definitely the Environmental Planning and Assessment Act in 1979 was far better in terms of how it was regulating land use activities than what this Act is in 1991 with something, and I'm talking about the Environmental Planning and Assessment Act in terms of people building houses. This, we're talking about natural resource extraction. So, okay, so as I said earlier, with production, we do require... Yeah.
So what you're saying there is that the person who explores and finds it could actually, with those figures you had before, could actually, if he did find gas, could hold on to it for 21 years without on-selling them the production rights.
I mean... Well, that's the exploration. Yeah, the exploration licence is for 6 years, but the production leases are for 21 years. So the production leases, you would need to be... There's all sorts of other kind of corporate compliance that they would have to be adhering to. So in terms of putting in reports and filing documents to say because obviously royalties are owed. So
they could hold on to it till the price gets better, to their own benefit.
That'd be an assessment lease.
Yeah, I think that...
They don't go to produce, they get an assessment lease, which is a kind of holding pattern.
Yeah, so that there definitely are some kind of stricter monitoring in terms of production. Like, for example, there was a coal company, it was a coal company, was fined quite a major amount of money through legal proceedings that were instituted against it because it actually produced more coal than what it was licensed to do, or more resource than what it was licensed to do. So once you're in a production phase, then certainly there's obligations, requirements, and they can be enforced against you. And bearing in mind as well, because once you're in the production stage, you have a development consent, it's likely you would require an environmental protection licence, and that licence talks about what you are allowed to do, what you're not allowed to do, and also you'd be having your production licence, which would be fairly specific. So I think in practice you probably wouldn't see someone sitting onto a production licence. But as Mark said, the assessment leases certainly you can hold on to. And interestingly, what I've just sort of noted over in the Pilliga is while there's exploration licences, and exploration licences lapse after 6 years if they're not renewed. It's interesting because out there it looks like there was quite a degree of sitting on particular licences and resource before things were renewed, and then at the very 11th hour things were renewed, but work schedules weren't necessarily kept up with. But I think that the company does have to make quite some serious commitments about what it is doing through its time.
The right government come along.
Maybe so. Yeah, possibly so. So in terms of production, primarily it's through the nature of needing to obtain development consent. And as I said, most of these projects, we're talking about state significant type of developments. We're talking about the bigger kind of projects. So you're looking at, you would be notified of it through a big advert in a newspaper or something like that, and then that's when you go, okay, we've got 30 days to put in a submission and say what we think about this. The other thing is I suppose in terms of appeal rights to when things are approved. So, for example, as I said, and as Mark said, we've just instituted proceedings. Obviously we would only do that if we thought we had reasonable prospects of succeeding. But we've commenced those proceedings on the basis of a really, really, really limited ground of review, which is what we call judicial review. So we can't go to court and argue that the merits of doing a major gas production project in the Gloucester area is going to impact on the environment in these ways, and here's all our scientific evidence. We can't argue that. We don't have that right. That's a political decision that we can't interfere in. But what we can do is say, well, was that decision made in accordance with law? And clearly we've got some very, very good barristers' opinion that perhaps this approval really hasn't been done in accordance with the law. So, and of course we're attempting arguments such as Mark kind of introduced the whole night with, well, does this actually breach the precautionary principle, the very, very fundamental term that, when there are risks of serious harm to the environment and yet we don't know the full scientific kind of we don't know the full science and there is uncertainty, whether or not we know the answers scientifically or not, we can't use the fact that we don't know as an excuse to just allow this project to go ahead. And in fact, we have to act differently. We have to take that kind of precautionary approach. So it will be very interesting proceedings. It'll go on and on for the next little while, but clearly we're trying to have a go at making this, strategically having a go to make this legal system a little bit more robust when it comes to something like coal seam gas production. Yeah. Of projects. Well, that's right. I mean, look, you don't know, and it's whenever the company's ready and whenever the minister's ready to put those projects on exhibition. So, as I said, for exploration, which is what we have down here in this particular area, we, in terms of round Grafton, we're still we're still continuing with exploration in this particular area.
There's only been RES done for the exploration works in this area. No one's gone to production.
Yeah. No, that's what I'm saying. But are we still actually doing exploratory works here now? Yeah. So at the moment, we're still doing the exploration. We don't know what will happen next in terms of what Metgasco's ideas are for down here. In terms of what we saw in the casino region, it's already done and dusted. We've got a development consent and approval from the state government that says Metgasco can build that power plant, and it can do all of those wells that will feed into that power plant, and it can also have its major fracking well, its Kingfisher well. So that's already happened in terms of the approval, and it went on exhibition, and I think about 5 people made a submission, and then it was all over and done with. Oh, okay. So in terms of where things are on exhibition, they are advertised on the current Department of Planning. Well, what's it called now? It's not planning. Planning and Infrastructure. So it goes on the Department of Planning and Infrastructure website, and you access the application there and all the assessment documents, and then you can lodge a submission either online or you send it in through the mail. So, I mean, that's how the kind of state approval system works. If we're going to see any more kind of major projects in this area, then yeah, there would be notice. And the state government is in the practice of putting notices in the local newspapers as well. So you'd see something in the Grafton Examiner from the department if it was a project like that, saying this major project's now on public exhibition, you can have a say. So yeah, but at the moment, and I'm speaking not that confidently at the moment because the system is in the process of changing. We've got kind of transitional arrangements for existing projects, but it is likely that these kind of gas projects will remain, gas production and mining activities will remain kind of the domain of state government, and they won't be handed back to local government. So yeah, it will still be that kind of through a newspaper or on the department's website. You know, and most importantly, I suppose it's people that are keeping an eye on this stuff all the time, the ones that will be writing into newspapers and trying to make that kind of community awareness that these things are happening. And I suppose it's staying in the network, you know, it's finding out through your networks of people. So as we said, the past government announced the tough new laws. There's no legislative change, so the current government's not bound by anything. But we were told that the Department of Planning, this hasn't been updated. We were told that the then Department of Planning and now Office of Environment and Heritage will review all the work plans and the REFs, the Review of Environmental Factors, including looking at what fracking chemicals will be used. And we've also been told that councils will be made aware and the landholders will be made aware. This is at exploration stage. Really interesting now in terms of given the councils that have said that they're, that they support a moratorium on all coal seam gas kind of activities. So, in terms of, it would give, if there was another application for an exploration licence in this area, if they weren't kind of already done, most of them, then, all these councils that have said they support a moratorium, it would be their opportunity to write to the Department of Primary Industries Minister and just say, hey, we don't support it, go away, we're really not happy about it. But anyway, so in a way it's a shame, I suppose, that this kind of awareness wasn't happening some time ago. But, it doesn't matter, it's happening now, and it's important that councils are taking the kind of actions they are. And this notion of banning BTEX is being examined too.
You've outlined some legislation which seems to be pretty powerful leaving out local government. How does local government place a moratorium? How do they enforce that, given the legislation and stuff?
Well, that's right. It's very symbolic, really. It's very symbolic because at the end of the day, it is state government administered, this stuff. So approvals for, so the approvals for exploration, state government. The approvals for production is state government and is likely to remain state government. Look, there is definitely, there is, in terms of production, there are procedures in the legislation that give local government a real consideration and a real voice. So that will be when it gets its voice. In terms of having a power of veto, it doesn't have that, but it can certainly, if it can show cause and show reason why it thinks an application for development consent ought not be granted, it's a very strong voice to come from a local government. But I see every day local governments putting in submissions against Part 3A subdivisions, but state government might take that view into account, but it doesn't necessarily follow through or use it as a basis to refuse development. Normally what will happen is it's that kind of process where, right, that view gets taken into account and certain modifications will certainly be made, perhaps, to a project, but in terms of actually being the basis for a refusal, I think it's a very good and symbolic sign of local governments, because I think, and I say that from a perspective, not as an individual who might be a bit frightened like other people that we might be stuffing the environment from coal seam gas exploration, and I'm not there on that front, but what I'm saying is, in terms of what I can legitimately see a case for, which is some genuine law reform into, the year 2011 where we're sitting now, this type of thing is a really good notion to send a message to the ones that can implement better laws to protect the environment and communities. So in that sense, I think the weight of what councils are doing by passing these resolutions to have moratoriums, the weight really is in that kind of that voice of it's time for some law reform on this.
But if you are saying that our local council declares a moratorium, but the company can go out there and continue to do everything it would have done anyway, right up to the point of development consent.
I think if you read the announcements from council, they usually say they're calling for a moratorium.
Yeah, they support a moratorium. Yeah, yeah. So, and that's
directly at the state government.
Yeah, so
Local residents.
that's right. So basically, as I say, it's a cry for law reform. That's what they're saying. And the moratorium, everybody kind of is aware, is just a breathing space to go to the Parliamentary Council, get them to sit down and start drawing some proper laws to regulate this kind of land activity, in line with any other intensive use of land at the moment. For example, you know, I mean, really we can say coal mining and other type of activities where we're extracting natural resource, they do go through a more rigorous process than what happens here at the moment legally. Maybe not a great process, but more than this. Yeah.
So just something I came across today, and if you could just clarify that. So we've talked about assessment and like a trial period of doing their research, okay? So something I came across said when it's a trial or assessment time, there's no environmental impact statements required, and they get this opportunity to trial for 2 years. Residents, community members and so forth have absolutely no choices when it comes to objecting.
Yeah,
So
that's right.
That's what we're talking about,
Yeah.
isn't it? Like, so when we get to production stage and they put in for their licence, okay, we may get, and our councils may get a say, slight,
Yep.
but in that, like, you can do a lot of damage in 2 years.
In 2 years. Well, look, that's what
That's what you guys are saying.
Well, it's actually 6 years.
To help that?
Yeah. Well, that's what we would be, any objective appraisal of a kind of modern, contemporary legal regulatory system that's up to date would certainly be better than this. Given, I say that in terms of weighing and balancing what the activity is we're talking about. And I mean, it's 6 years, so it's not just 2 years. They can be doing that for 6 years. So yeah, in terms of, in terms of what they can be doing, and as I've only...
You guys are fighting for
well,
to try to...
we're not campaigners, of course, but it's what...
we want to happen, yeah?
Yeah.
That's what we want.
Absolutely. And look, without a doubt, the EDO, and it's on our website, we put in a paper to the last New South Wales government announced and released a coal and gas strategy scoping paper and asked for submissions on that scoping paper in the development of a strategy for coal and gas. So we certainly lodged our submission and put some things in there. And yep, we said that. We certainly said that a moratorium on coal seam gas extraction and exploration, while a strategic plan is developed, is really what's required. But again, that was the last government that set that up, and so what we've got so far, so the coalition or the current government policy on coal seam gas, and this is really important to kind of know, and the big take home at the moment is there will be no, we haven't heard that there will be a moratorium on coal seam gas or any ban on fracking. So, and in fact, all indications are that that is not what would happen. Better standards to prevent inter-aquifer leakage. That one I'm a bit critical of this, because I kind of go, well, hang on, better standards. We can have the best standards in the world, but the fact is, what it would appear, and what the kind of the material that I've looked at. Okay, we can have really excellent standards to prevent this kind of thing happening. But it's more to the point is we've got to actually consider what we would do if it happened. And I think we really have to ask that question legally as well. Like, how do we deal with that kind of scenario? Or are we just going to kind of keep our eyes closed to that potential completely? And because the reason I can quite clearly say that is because I've seen the legal regime that talks about, say, for example, protecting threatened species, but what we've never done is talked about, well, if those best practice standards don't work, are we prepared for the extinction that we will cause? We've just never asked those questions in our kind of legal structure. So, and I think it's about time that we do kind of ask these questions. And internationally, people are asking these questions in other kind of legal culture. So the idea of protection of prime agricultural land, clearly that's a no-brainer. It's really, really important. The review of access arrangements and the banning the use of evaporation ponds. Well, clearly that's the Queensland experience, and that's why New South Wales coalition government has looked at that and said, well, it would appear from the Queensland experience that we might need to ban those evaporation ponds. Well, that's the question. Mark identified a couple earlier. So one of the things I think I remember was it Tony Burke at the Commonwealth level was talking about this idea of re-injecting back into the seams, the salty produced water. I don't know whether that's a good idea or not. Anyway, but obviously I'm not a scientist. I just wouldn't know. But that was certainly one idea. The other is, through osmosis and cleaning the water up, all those sort of things that all those things that we're really good at. So in terms of, sorry, I say it a bit cynically, really, don't I? So in terms of what we're saying at the moment, what could be better, as I said, so this idea of a moratorium to have a bit of breathing space, to slow down the activity. I mean, at the end of the day, really for all of us, what is the hurry? Okay, well, we know what the hurry is. We're kind of addicted to this stuff that we really need energy, and we're looking for alternative sources big time. But if that is really what we're doing and looking for alternative sources for coal, one of the interesting things is some of the latest research. It's like, it would seem, following the kind of increase of activity with coal seam gas, it would seem that most of the momentum in the last 3 years has come from this idea that we need a transition of energy to move us to a lower carbon future. I think we've got to go back to the beginning again and ask the question, well, scientifically, is this it? Because if it's not, what the heck are we doing? I mean, that's I think kind of one of the logic questions. Whether it's one of the legal questions, I'm probably going a bit outside my field. But so a triple bottom line assessment. So we're looking at this idea of, really, we need to, again, another kind of up-to-date component of a good legal regime that is up-to-date in terms of an environmental legal regime is looking at cumulative impacts. This, at the moment, all we're doing is looking at well by well, project by project. We're not looking at the whole picture here. One of the interesting things has been very much Tony Windsor's push, and he was one of the first to really kind of start flagging this idea was, hang on a minute, can we just get a regional assessment perspective on this? Can we start looking at our water reserves in terms of the regional perspective? Clearly his focus has been on the kind of Murray-Darling Basin and the feed-in and that kind of essential water source. But over here, say on the North Coast, are we looking at this Pell by Pell, or are we looking at this in terms of the whole North Coast and all of the water systems that we have here, whether they be our groundwater and our surface water systems that we have here flowing on the East Coast? Well, we're not. We're actually not doing that. And if you look at a review of environmental factors, you'll certainly see we're really not looking at cumulative impacts. And then the notion, as Mark introduced the whole night, looking at this concept of ecologically sustainable development and not just looking at it going, oh yeah, ESD, yeah, we've been doing that for years and years. It's looking at it and really, really having a go at trying to implement those measures within what we're doing. And again, as I said, the litigation that we've just commenced today, is kind of begging the legal system to have a good look at that concept. Are we really looking at the precautionary principle here when we're granting consents for these kind of major land use activities? So the other thing is in terms of landholder rights. Has anybody here actually been approached by the company, and has anyone got a landholder access arrangement in place? No, because this is really your first, as a landholder, this is a member of the community. Normally, this is their first introduction to coal seam gas mining or extraction and exploration. Basically, you will get a kind of knock on the door, and it will be someone, a company representative, and they will say, hi, I'm here from whatever company, and here's a notice to you. The notice has to comply with particular sections of the Act, so it's got to give you a really, really clear idea of what it is the company wants to do on your land, how they're going to do it, when and exactly where on your land they want to do it. So basically that's the first step. It's a company coming to you to serve a notice of intention to enter into a landholder access arrangement. Okay? So that's how it works, and that's how they start. And from that moment on, basically you're more or less in a process that you actually can't get out of. You can't say, thanks very much, it was lovely to meet you, see you next lifetime. It doesn't happen like that. They're there, and they will then, from that moment on, you are forced to enter into an agreement at the end of it. That's where you will go. If you don't agree, if you don't agree, there are some good measures in there to protect your interests in terms of what that agreement will look like at the end. But in terms of getting to the end, if you don't take yourself to the end, the arbitrator or the Land Environment Court takes you there. So that's how it kind of works. So basically, there is some really good information available to landholders, but the primary message is, and the real take-home message is, if you do get a knock on the door, you don't have to sign anything there and then. What you have a right to do is say, thanks very much, I'm going to seek some legal advice, thank you. And that person, I imagine, would be very, very respectful of that desire. And then, I would suggest that that's when you go and you get some legal advice about really how best to protect your interests. Because, as I said, there's a fantastic fact sheet on the New South Wales Farmers Association website about communication strategies for people. And basically there are ways of really protecting your interests, and there are certain things in there about the sorts of things you really ought to be thinking about in terms of your land use. And the premise for that is, whilst it may be something in the beginning as benign as, slashing a 4-metre track through your property to do some seismic activity work, it can lead to, obviously it would have to be anticipated in the agreement, but it can lead to an exploration well, and then of course that well, what I've very recently learned, that well can actually end up being a test pilot production well as well. So well. So so it's important that it's important that you get good legal advice about it, and also in terms of that legal advice, your agreement can also reflect that the company will pay for your reasonable costs in terms of seeking your first instance legal advice. So it's not one of those things that you need to sit and go, well, hang on, oh no, I'm having this forced upon me and I've got to pay my own legal costs, etc. There is in the regulation, if you ask the company to pay for your reasonable legal costs, then it has to do so at law in terms of getting that first preliminary initial legal input into the negotiation of your landholder access arrangement. Yeah.
Can you refuse to take the documents that this person is going to give you? And if you don't take them, has the process not started?
It's not. It just isn't that simple. So basically, if what we've had in the last few weeks is there's an organisation, I don't know if anyone's heard of them, but called Lock the Gate. They're a very, very kind of active landholder-based kind of movement or organisation that I think it started through the coal mines, really. Lock the Gate, I think, started from the sort of Karuna type actions further down Liverpool Plains, and but basically they've been very lateral in their thinking and in terms of looking at options for private landholders. And I've been asked recently to look at this kind of question: if I have one of these on my fence, can I avoid the big picture of coal seam gas for the rest of my life? The short answer is no, it doesn't work like that. Sorry, the long answer is no, it doesn't work like that actually. But the short answer is yes, it can. It can be effective to a certain degree. So one of the things, I'm not advocating people go out and put signs on their properties. I'm just telling you about what I've seen. But So one of the things is this idea that if you have a sign that says, a person's common law right to enter is expressly withdrawn. Admittance via invitation only to all persons and entities, otherwise trespass applies. And it's lovely really because they've cited this High Court case, which is Plenty and Dillon, and it's a fabulous High Court authority on trespass. But I can assure you, if you're paying for a sign to be made and you're paying by the letter, don't worry about the High Court citation. It's really, really not important. I think it's one of those kind of beautiful aspects of kind of, Australian society engaging with this kind of lovely notion of common law, So while I think it's, but what is really important about the sign and what is really important about the High Court case and cases that have followed that case, so more recent cases in the New South Wales Court of Appeal, is that the fundamental premise that your private property is your private property, it's a sacrosanct principle in common law in Australia, and that the notion of your peaceful enjoyment to the exclusion of all others, the castle kind of thing, it is still very alive and well in Australia and in New South Wales law. But what we also know is that, Parliament can come up and Parliament can jump on all sorts of common law rights that we have, and they can legislate and make, the written law very different. So clearly, where an authority has a statutory right, such as the Rural Fires Association, there is a statutory right to be able to enter property, trespass and do whatever it likes to rid the threat or the risk, etc., of fire. There's also a right for, the police in where they formed a reasonable suspicion to come onto your premise. That reasonable suspicion is, that there's the commission of a crime or a crime, etc., being committed. However, what is remarkable is if the police are just coming to serve a summons or a warrant, or the police are just coming to serve a notice on you or something like that, if you have a sign, something like this, or your consent for them to be on your land is withdrawn, then in theory, everything they do from that moment on is unlawful. So if they are serving, so for example, so we'll just go straight back now, and I'll take you right back to, Mrs. Coal Seam Gas is walking up your driveway. If the minute you see that person, or there's a sign here on your fence, then that person walking up your driveway, when they see this sign, really ought to know that there's a clear message being sent to them, that they really have no authority to be there anymore, because what that Plenty and Dillon case said was there is an implied authority for anyone to enter private land, to knock on the door, to say, hello neighbour, okay? But the minute that implied authority is removed by something like that, then no longer can you have that kind of lawful purpose for being there. Yeah. Well, you can write one. You can write one up yourself, I suppose. You can draw one up as long as it's clear. And so then the other one is, of course, if you see someone coming up your drive and you suspect they're who they are, you literally, before they get a chance to say anything to you, you say to them, hey, any authority you thought you might have had doesn't exist. You're on my private property. You have to leave, and then maybe put your fingers in your ears or something. I don't know, so you don't have to hear anything else. What's that? Yeah, sure. Well, be careful. But no, so look, the reality is all that will do, the utility of that is not very long lasting, because the legislation provides other means of serving you, and like any service, so as a lawyer, if I'm organising service of the commencement of proceedings, I've got all sorts of ways of doing substitute service where somebody just won't accept a document. So one of the things in this law is it's. Yeah, well, that's right. This law provides that. That's right. No, I always go with myself. No. They, so this law provides that simply by posting to your residential address or your business address, is enough to consider service done. Clearly, the company would have to prove or show cause that they've done that. But the reality is that, all that. What this does, interestingly though, and I thought about this a little bit, and interestingly, I suppose what it does is it can make a job more difficult in our rural landscape, particularly where, then basically I suppose what has to happen is a representative from the company gets engaged to go through all the property titles, find out your name and then get your address and then send you the documents. So, whether that's a week, a month, a year. The other implication, I suppose, when you think of these things pragmatically is, what we've been told by the companies that we've had speak at sessions and that we've heard speak, basically they say, if we don't have a willing landholder, then we'll simply go next door, or we'll go next door. Because the nature of exploration, of course, remember, is it's a broad area and there's a lot of choices, of where to go. I suppose it causes a problem where they really need a continuous seismic line in terms of exploration. But in terms of wells, etc., I know what happened in the Kirong Valley, just between Lismore and Nimbin, that area there where there was an exploration well, basically the community was quite aware that, the one person that was going to consent to the type of activity on that property was the one, that they kind of went to. So somehow it was quite obvious there was come here. And of course, through the compensation measures, and these are the sort of things you negotiate in your access agreement, there is compensation for landholders. When you have a well like this on your property, you are owed compensation. And there are ways of making those, coming to the price of what that compensation is. And as I understand it, not only are people sometimes compensated in terms of you might get some cash for the use of your land, but also there are what we know of is some generous enticements in terms of certain landholders. So, there are people where definitely they get new fences, new gates, new roads, that sort of thing put in on the property. And, obviously for a lot of people out there doing it pretty rough, and, sure, the price of cows went up, but, it goes down again. These sort of things are really, really inviting, especially when you're told that basically what's happening on your land is pretty benign and it's only going to go on for a little while. So these are the sort of things that are happening, and clearly some people are in the position where that's an exciting thing for their private property.
I think it's worth pointing out that compensation is not going to make up for the loss of people trying to sell their properties when they know this sort of thing's happening, and I've already heard of a case of that happening around Grafton. The evidence is actually, particularly coming out of Queensland now, is showing totally the opposite, that land values are diminishing and people don't want to buy properties in those areas. And we talked about compensation, and Alan just raised there, the amount of compensation that I'm aware of that you're given is negligible to what they will do to your property.
Yeah.
And to us, or some of us here anyway, it's just not on. We've invested our lives in these properties. Some of us do. I'm a farmer. Some of us do. We've invested our whole lives in this. And they say, but this is for the betterment of the community. Well, if it's for the betterment of the community, why have I got to make a donation of $1 million or $2 million to the state government? If the community want my property, well, then they have to pay for it. Talk about use paid, knowing that it suits them. That's the point for us, like the environment, okay, I fully agree with that. That's a very important part of what we have to have, our water and all that, very important. But the other side of it is too, the human side of it, which isn't really touched on in your presentation very much, is something else that people aren't looking at. Like I say, if we're living under a cloud, I'm not going to invest any more money in my property, because am I going to have a property, first of all, and what's the value of it going to be? So why should I invest any more of my money in it?
Can I just say something? I had a call from the reporter at the Examiner asking me if I knew whether there was an impact on real estate prices, and of course I had no idea. But the point I made to him was that you would have to go a very long way to get away from an area on the north coast that was not potentially affected by coal seam gas exploration. So remember, this is the map of the areas on the north coast that are covered by leases, and this large area of the whole state is covered by leases. So the fact that a lease covers, an area including your land doesn't mean that anything's going to happen, and the companies, have very little chance of being able to exploit every little bit of their lease. I know there's a risk, but in terms of the impact on property values, it's much more likely to come, if they're doing exploration and the exploration goes well and that they look like they're doing production.
Yeah, but if, for argument's sake, the bloke next door to me comes to an arrangement like happened up in Geelong Valley, wherever the lady said, then that devalues my property next door to him.
Yeah, and that's
What I'm saying, if
yeah.
I've got a property worth $1 million today, McGasco come in there and tomorrow it's only worth $500,000, so suddenly I'm $500,000 out of pocket.
Or in some places in Queensland they just can't sell them at all.
Yeah, that's right, and I think that's right. And look, I mean, you can.
The farmer.
Yes.
They don't do it in towns or in government house. It's always on the farmland.
Well, it's really interesting actually you say that, because at the moment there's a number of exploration around Sydney in where's the actual area? Yeah. So it's really interesting that this is the one issue in all my experience that I'm seeing where everyone is affected. It's really interesting, and I mean,
Well, and also around,
that's right.
the Eastern Star Gas is planning on clearing 2,500 hectares of state forests in the Pilliga.
Yeah.
To do this, so it's not only farming land.
Yeah, and that's one of the fears as well, is that, and I think this is a point in terms of the sort of advocacy and the community mobilisation. I think it is one of those issues that may actually make everybody more aware of each other's concern, because for the first time ever, I think people are saying, well, hang on, it's about farmland. But then you've got the voice over here going, hang on a minute, if we protect farmland, we know where this is going to go. This is going to go straight to our public land. And then you've got, the one thing that is drawing all land together and all people together, and that is, hang on, this is our water that doesn't discern between property boundaries or tenures. And at the end of the day, I know there are so many fundamental differences between the American fracking experience through shale and what we're seeing here. But one of the common themes that we did see was where the groundwater experiences serious problems. They're not isolated problems. They're not isolated to a particular area. So I mean, they are the sort of things. So for the first time, it really is about so many varied concerns that are all coming into the melting pot, and I think it's important that that everybody, in considering it, is remembering every aspect of where the harm is being felt.
I think what people need to also be aware of that, according to McGasco, if they decide to get the approved and go into a production well set up on your property, you can have a well approximately every 200 acres, sometimes even smaller. Well, a lot of us landowners, 1,000 acres, 200 acres, whatever. So, I mean, all the infrastructure that goes with that one production well, basically the 200 or 300 acre properties, you can't use it anymore.
Yeah.
Remember what's in the legislation about the distances.
200 metres.
So they can't have a well within 200 metres of a dwelling, and they can't have
200 metres from your house is not very far.
Yeah, it's not very far. That's right.
Okay, I'm just telling you what's in the legislation. 50 metres and nothing on any cultivated land.
Without the written consent of the landholder.
Yeah. 50 metres from orchards and gardens.
What I understand is cultivated land is like we cultivate land to grow crops to feed our cattle. I'm being advised that doesn't count.
I think the definition is getting a bit better in terms of cultivating land. Like, it can even be land where literally you've just got some improved pasture on it. It can also be land that is, grown for silage. So you can actually have.
So go spread that loose.
Note saying that cultivated land does not include improved pasture. There's actually a note in the legislation.
I thought it was. Yeah, and I thought it was a certain amount of improved pasture. I think it's gone to, look, I might be wrong, I may be wrong, but I thought that, I read it the other night where I thought it said that it was a portion, if it was under a certain portion of improved pasture it wasn't, but anything above was.
You want to see what they're doing around Narellan.
Yes.
Just on the outskirts of Sydney Gas. And they seem to be able to drive anywhere and go to kick up dust right beside people's homes.
Yeah.
It's disgraceful.
Yeah. Well, that's right. I mean, and that was certainly a concern. I know when Metgasco first started doing their activity up a little bit further north, and we certainly got contacted by a number of landholders that had entered into access arrangements because they obviously felt they had to, etc. And then they were saying, these guys are driving past my bedroom window every morning. I thought they weren't allowed to go closer than 200 metres. It's sort of like, well, they're not allowed to do their activities closer than 200 metres, but if that's where the access road is and you haven't agreed to anything different, so those sort of things are really important in terms of organising the arrangements. So, one person that thought, they'd kind of made an arrangement that was all right because what they were doing was over there, but they never actually thought about, the vehicles that were going to be driving to get there and from, those sort of things, yeah.
Everything's been talked about coal seam gas, and I've heard that Metgasco is doing the same now. They're finding a lot of natural gas. Now, is the same legislation going to apply to natural gas?
Well, Mark did mention it's all still the petroleum because it's all still the same. Gas is the same kind of compound.
Saying coal seam gas.
Yeah.
No one's saying natural.
No, that's
It's going
right.
to be the same thing, and if they get some sort of stop for the coal seam gas, but natural can go ahead, Metgasco will just tell it's natural anyway.
Well, the interesting thing is, that's what Mark identified, that the one well that they are planning to fracture, Metgasco's at Kingfisher, is actually natural gas. So, look, at the moment, we are saying coal seam gas, but perhaps that debate will be broader, I don't know, and it will evolve as we learn more. But at the moment, it's definitely coal seam gas.
Yeah, at the moment, the preliminary advice from Metgasco is that what they've done with Coaldale is actually sandstone again. So we should be talking about gas mining as the issue, not coal seam gas mining.
Yeah.
Yeah, and that's confirmed to us. We've actually had contact with Metgasco geologist Steve Stanmore, and that he informed us that that's correct.
So it's sandstone and it's natural gas, yeah. Well, and as Mark said, that's what every time they put something down, they find something great, we seem to, this North Coast region seems to just be incredibly lush and full of the particular natural resource that is, the kind of fad at the moment. And as I said, is it the fad at the moment because it was the one that's been identified as the transition, source? So, sorry, you wanted to say?
Just wondering, what's the likelihood of going after the actual coal once the gas is gone? What's the likelihood of coming back and mining the coal? Or is it secondary?
No idea, but they're different companies, different industries. It's a long way down. We're going a long way down. It would be. I know there's kind of longwall mining under Sydney and the Illawarra, but I don't know. My understanding is that coal in Coaldale area anyway is not really any value as far as the mining side of things. Right.
And also, if you think about, coal mining activities, as Mark said, you can do all the underground stuff, but the most, the most common way we see and the most cost-effective way are these massive open cuts, and clearly it would be...
while we keep approving open cuts, there's no need.
Yeah, that's right, yeah.
Well, ladies and gentlemen, the issue is well and truly before us, and for that we have to thank a 2-hour and 10-minute effort by Sue and Mark. For this, please put your hands together. A brief message now from John.
I'd like to thank everybody for coming along tonight. We've got some coffee and tea and a few...
The microphone.
We can't hear you, John.
Oh, yes.
I didn't want all of you to stay. No, there's sandwiches over there and some nibblies and coffee and tea, and I hope you take the opportunity to stand around and maybe chat with people and find out what their concerns are. There's also a little jar over there for donations to help towards the catering if you feel that way inclined.